All right. I think that is it's time for us to start. So I think this may be everybody for now. Um, we will go ahead and record this session so that it'll be available to more people later on. But I want to go ahead and thank Mr. Zach Passmore for joining us today and for sharing some information about the Landlord Tenant Act. Zach Passmore joined the South Carolina Department of Consumer Affairs in 2019 and is the complaints attorney for the department's legal division. His work includes the mediation of consumer finance, vehicle repossession, and debt collection matters. Prior to serving the state of South Carolina, he worked for several years in private practice litigation. He is admitted to practice law in South Carolina and has an undergraduate degree in criminal justice from the University of South Carolina. And he earned his Juris Doctor from the New England School of Law in Boston, Massachusetts. Thank you so much for joining us. I really do appreciate you taking the time to come talk to us today about this. And real quick, if there are questions throughout the presentation, if you just drop them in the chat, I'll keep an eye on that. And then if we have time, we can go back afterward. So Zach, with that, I turn it over to you.
All right. Well, thank you so much for having me. And like it says on the screen there, my name is Zach Passmore. I'm the complaints attorney for the South Carolina Department of Consumer Affairs. I'm here to speak a little bit about the South Carolina Residential Landlord Tenant Act. It's a rather lengthy subject, but hopefully after today I can provide you some pointers, some important things regarding the residential landlord-tenant relationship here in South Carolina. So today we will discuss the Act itself, including general provisions, the responsibilities that landlords and tenants have to each other in regards to cooperating under the lease agreement. We'll talk about remedies that landlords and tenants have if the other side happens to breach the lease agreement. We will talk briefly about security deposits. And just before we get started, I have to put up this disclaimer, as all lawyers will, that this is not meant to serve as legal advice, but rather this is being presented for informational purposes only. So, of course, if you have any specific legal questions, I would suggest you talk to a private attorney. So before I get into the Act, let me talk a little bit about my department. So what is the South Carolina Department of Consumer Affairs? It is the state's consumer protection agency. It began operations in 1975, and it is the administrator and enforcer of the South Carolina Consumer Code, or Consumer Protection Code, as well as other regulatory statutes outside of our code. In this capacity, the department helps to formulate and modify consumer laws, policies, and regulations, regulates consumer credit marketplace, resolves complaints arising out of the production, promotion, or sale of consumer goods or services in South Carolina, whether or not credit is involved, and promotes a healthy, competitive business climate with mutual confidence between buyers and sellers. So the way that we accomplish our mission is through our four divisions, or through our four methods of our mission statement, which would be advocacy on behalf of the consumer, mediation of issues between consumers and businesses, our enforcement activities regarding regulated businesses, and the education of the public. So the first division in our department that I want to talk about is our Consumer Services Division, which provides South Carolina taxpayers with a readily available, experienced, and cost-effective mediation service. So our consumer services attempts to resolve consumer complaints against businesses, and we receive approximately 300 complaints a month that consumers file either through mail or online regarding businesses both in and outside of the state of South Carolina. And on average, year over year, we get about $1 million in refunds, credits, and adjustments for South Carolina consumers. So our largest division at DCA is the legal division. and it performs the agency's licensing, administration, and enforcement duties related to the majority of the 120 laws under the agency's jurisdiction. So the General Assembly has charged the DCA with advising the legislature and governor on consumer issues and state of credit in this state. And while doing that, we process approximately 26,000 regulatory filings annually. And there on the right side of the screen, some of our regulated industries include credit counselors, physical fitness centers, pre-need funeral contracts, mortgage brokers, prepaid legal services, and pawnbrokers. Our identity theft unit provides education and outreach to consumers across the state to help increase public awareness about what identity theft is, the steps consumers can take to protect themselves, and what consumers should do in the event of identity theft. The unit also handles administration and enforcement of state identity theft-related consumer protection laws, including receipt of security breach notices to ensure reporting and notification requirements are met. And finally, our Public Information Division, the ones that made this presentation possible, serve as the main consumer education portal for consumers, business, and media. So part of our outreach to the public is to make presentations and sponsor webinars. And they also disseminate press releases and consumer education brochures. So with that out of the way, I can talk a little bit about the South Carolina Residential Landlord Tenant Act. This is the state law that concerns the residential landlord-tenant relationship. And as I said earlier, provides things such as obligations of each party and the remedies for breach. So a little bit about the Residential Landlord Tenant Act. I have up here the citation if you want to delve into it a little bit deeper. You can go online and you can find South Carolina Code of Laws, Title 27, and you'd be able to find the Residential Landlord Tenant Act here at 2740-110. It was enacted in 1986, and it applies to rental agreements for dwelling units located in South Carolina, regardless of where the agreement was entered. And a dwelling unit under the Act is defined specifically as a structure or part of a structure that is used as a home, residence, or sleeping place by one person who maintains a household or by two or more persons who maintain a common household. And this includes landlord-owned mobile homes. So down here at the bottom of the slide are some things that it does not cover. So detention facilities, medical, geriatric, educational, or religious facilities, hotels, occupancy under contract for sale, or residence at a charitable or emergency shelter do not fall under the definition of a dwelling unit. Another thing to point out is that property that is leased for the exclusive purpose of being renovated by the lessee is not considered a dwelling unit under the statute. So let's start with the cornerstone of the landlord-tenant relationship, the lease agreement. So leases do not have to be in writing. And if they are not in writing, they are typically, well, not typically, but they are considered to be month to month for the purposes of their enforceability under the Landlord-Tenant Act. Rental agreements that are not in writing or are unsigned but provide for a term longer than a year is only effective for the term of 1 year to comply with what's known as the statute of frauds. If the written agreement isn't signed by both parties but rent has been paid and accepted under that, that is the same effect as signing, so that would be a lease that is enforceable. And lastly, prohibited provisions under the Landlord-Tenant Act are unenforceable but do not necessarily invalidate the entire lease. So some examples of that would be, for instance, agreeing to forego rights and remedies under the Act, or agreeing to the limitation of any liability for the landlord arising under law, or indemnifying the landlord for their liability. As I said, prohibited provisions in a lease agreement are unenforceable, but they do not invalidate the entire agreement. So the enforceable parts of the lease agreement would still stand. So under the Act, it describes certain obligations that landlords must have or that must comply with. So first, they are required to deliver possession of the premises. So they have to make sure that the premises or the unit or property is able to be transferred over to the tenant. And if need be, the landlord can bring an action in Magistrates Court for possession of the premises against the person wrongfully in possession. That's what's commonly known as a holdover tenant. So if there's a situation that a previous tenant will not leave, it is the landlord's responsibility to deliver the premises to the next tenant, usually through Magistrates Court. The landlord is obligated to maintain the premises. Under the statute, that includes complying with any building codes, keeping the premises in a fit and habitable condition, making available running water in reasonable amounts of hot water and reasonable heat. So that reasonable amounts of hot water doesn't mean that it's unlimited hot water, but it's got to be a reasonable amount, which I'm sure is something that would be determined in court should that issue ever arise. As far as I can tell, it hasn't arisen yet, at least from a court standpoint. The landlord is also required to maintain all HVAC and electrical and plumbing systems and any appliances that have been provided by the landlord. So that's a pretty important point that the Residential Landlord Tenant Act adds. Previously, under the common law, a landlord had no duty or obligation to make any kind of repairs. But with the adoption of this act, the landlord must make repairs to make the premises fit and habitable, provided that they have notice of the defect. And that's something that I'm probably going to harp on a good bit during this presentation, is the notice requirement, which I'll explain more moving forward. One thing to note is the landlord and tenant of other than a single family residence may agree that a tenant will perform specialized repairs or remodeling as long as these repairs are made in good faith and repairs are not necessary to bring the unit up to code. That would be like a resident supervisor, something of that nature. So this slide has a few case law interpretations. Here in South Carolina, there hasn't been a whole lot of case law developed on this subject, but there are some rather significant holdings by the courts. These first two, the Robinson versus Code and the Thompson versus CDL Partners, those mainly have to do with stressing how important the notice requirement is to try and get any kind of remedies under the Landlord Tenant Act. So Robinson versus Code, for instance, the landlord's failure to provide smoke detectors in the rental home, it was not actionable under the act because that landlord did not have notice from the tenant of the lack of smoke detectors. Same here in Thompson versus CDL Partners, the landlord has to be given notice of a defect to be liable for failure to make any necessary repairs. So the next case, Fair versus United States, that pretty much split the obligations between landlords and tenants. So the landlord's duty applies to the physical state of the premises. And then the tenant is responsible for other types of safety concerns, for instance, pets. So another point to be made there for the Fair versus United States is that a landlord is not responsible for providing protection to tenants against criminal activity. But if you look at this next case at the bottom, Pryor versus Northwest Apartments, there is no duty to warn for obvious conditions. That was something, in that case, a tenant slipped in common property after a rainstorm, and the court decided that the landlord did not have a duty to warn tenants about an obviously dangerous condition. But one thing to point out is that this case did say that landlord's obligations can extend to the common areas of the property. So that would, this case would not negate any kind of duty to warn for conditions that aren't apparent that could affect safety. So after the landlord's obligations, let's talk a little bit about the tenant's obligations. So tenants are obligated to comply with any building codes, as well as keep their premises that they are responsible for safe and reasonably clean. They must dispose of garbage in a clean and safe manner. They must use any facilities and appliances that have been provided in a reasonable manner. So they have to be used in the way that they are meant to be used. Obviously, a tenant cannot destroy the premises without incurring some sort of liability for the landlord. And they also, if they are not allowed to disturb others' peaceful enjoyment. So if you live in an apartment, you cannot infringe on anyone's peaceful enjoyment or any neighbors if you live in a single family home. These obligations also apply to tenants' visitors. So that obligation is transmitted to visitors as well. And tenants are obligated to comply with any lease rules and regulations that the landlord may create. And also, they must occupy the unit solely for the purpose of living there. They can't operate a business out there or at the unit without any kind of agreement. And of course, they cannot do any illegal activities. So talking a little bit more about rules and regulations. The landlord is allowed to create rules and regulations so long as they promote the safety of tenants and preserve the property from abuse. And these rules and regulations must apply to all tenants in a fair manner. A tenant must be given notice when renting or when they are adopted by a subsequent landlord. Usually the rules and regulations are attached to a lease as an addendum, so that would meet the notice requirement under the law. However, if these rules and regulations are adopted after a tenant enters into the rental agreement, the landlord can still create the rules and regulations, but they must not substantially modify the tenant's bargain, and the tenant has to be given 30 days in order to object in writing to any rules and regulations. So for the landlord's responsibility to provide access to the premises, or I'm sorry, no, this is the tenant providing access to the landlord to the premises. The landlord can enter a premises without consent, and that includes their agent under certain conditions. So at any time in case of an emergency, this includes prospective changes in weather conditions, which may pose a likelihood of danger to the property, such as an impending hurricane. Also, it should be noted that a landlord does not need consent even before a governor declares a state of emergency to enter with the purpose of protecting the property. So they can enter the premises without consent between 9 and 6 for regular scheduled periodic services, so long as they provide to the tenants an announcement of some sort of their intent to enter. It must be 24-hour notice. So they can put something up in the common area saying that they plan to do maintenance on the units tomorrow and they plan to enter, something of that nature. They can also come in between 8 a.m. and 8 p.m. if they are providing services that the tenant has requested, so long as they have also announced their intent to enter the unit with 24 hours notice. Landlord cannot abuse this right of access or use it to harass a tenant for any purpose. And a tenant shall not unreasonably withhold access, and this includes allowing the landlord to show the premises to prospective buyers. And of course, a tenant cannot change locks without permission. So now that we've talked a little bit about the remedies, now that we've talked a little bit about the obligations of the parties, let's talk about the remedies a little bit. So with any kind of alleged breach of the lease agreement or of the Residential Landlord Tenant Act, the tenant must give the landlord written notice of non-compliance materially affecting health and safety or the physical condition of the premises. And this is something that would be based on a case-by-case basis. Some examples that the courts have determined fit this description of non-compliance would be broken locks on doors, broken windows, structural damage, or water damage, or lack of smoke detectors, kind of like in that first court case that I had mentioned earlier, Robinson v. Code, the difference being that notice is required. Courts will typically treat a violation of local building codes as de facto non-compliance. And like I said, that's determined on a case-by-case basis. So once the landlord has written notice from the tenant, the landlord then has 14 days to remedy the breach. At which case, if they do not remedy the breach, the tenant can terminate the lease agreement if the landlord does not make repairs. However, there is an exception. And that exception would be if the landlord begins to make repairs within that 14-day window and completes the repairs within a reasonable time frame. If that's the case, the lease agreement stays in effect. Now, of course, the law does not define what reasonable time frame is. That's why I put it in quotations, because that's how the statute states this issue. So reasonable time frame would likely be something that would have to be determined by a magistrate. The judge will determine, after hearing the facts, what a reasonable time frame is in this situation. So if the agreement is terminated, the landlord must return the security deposit back to the tenant. And also the tenant cannot use this remedy and cancel their lease agreement if their own actions were the cause for the repairs. Before I move on, I know I get a common question regarding this section of the Act when it comes to the presence of mold in an apartment. And as far as the courts have gone, it does not necessarily reflect a health and safety issue that falls under this statute, but that is not an issue that has been definitively decided by a judge here in this state. So I just wanted to put that out there. If anyone was wondering about that specific issue, the answer is we don't know. But it's certainly something that could probably be brought before a magistrate. So there are remedies for the tenant if the landlord fails to deliver possession of the premises. So if that happens, no rent is owed to the landlord until possession is delivered to the tenant. And once the landlord has failed to deliver possession, the tenant can terminate the agreement with at least 5 days written notice, and the landlord must return the prepaid rent and the security deposit. So, like I said, no rent is owed until the landlord has delivered possession of the premises. So the common example of this is when a property has a holdover tenant. There's someone that refuses to leave the unit. That's the common issue when it happens. Their lease is up and they're not moving. So at this point, the tenant's options would be to either terminate the lease agreement with 5 days notice, or they can go to Magistrates Court and demand possession and bring an action against the landlord, as well as any person that is wrongfully in possession of the premises. So if the tenant chooses to do that, they are entitled to actual damages, which would be something like any kind of moving costs or any kind of costs incurred due to the delay of the move, any kind of additional secondary housing fees. But it also must note that the landlord is not liable for these damages if they have made reasonable efforts to obtain possession. And again, reasonable efforts, reasonable time. This is all things that are determined on a case-by-case basis by a magistrate. So on this slide, if the landlord fails to deliver possession, and they have done so in a way that is willful or intentional or in any way not in good faith, then the tenant may go to Magistrates Court and recover the sum that is greater of either 3 times their monthly rent or 2 times the actual damages that they've incurred, as well as reasonable attorney's fees. So as I said earlier, landlords must provide certain essential services to tenants. And of course, what does that mean? Well, this has been defined very specifically by the Residential Landlord Tenant Act as these things: running water and reasonable amounts of hot water, plumbing and sewer access, gas when it is used for heat, hot water, or cooking, electricity, and heat. So the landlord must provide these services when they are leasing out their property. Failure to provide these services will result in, hopefully, the tenant giving written notice to the landlord. Again, written notice is crucial to any of these remedies under the Residential Landlord Tenant Act. The tenant may get their own amounts of these essential services and deduct that money from their rent. Alternatively, the tenant's rent may be reduced in proportion to the value of the property without those essential services. This remedy does not authorize a tenant to make repairs on the rental property and deduct the cost of the repairs from the rent. That is something that some states do allow. It's not something that South Carolina allows by statute. Of course, that is something that a landlord can agree to once the situation arises. So, like I said, I keep harping on the written notice, but that's because these rights do not arise until the landlord has been given written notice and the landlord fails to act within a reasonable amount of time. I guess I should probably use this point to keep talking about the written notice. I will say what I tend to recommend to people when I get this question, how do I give written notice? And I say what I would suggest is to mail it certified. Mail it as a certified letter so that you have a receipt with a signature of who received it, as well as confirmation that it has been delivered. And that would be your evidence that you could take to Magistrates Court when these time frames come into question. So the tenant doesn't have rights until they've given written notice to the landlord, but they also do not have the rights if their deliberate or negligent acts or omissions cause the problem that is in question. So how does this work under the Act? Typically, these remedies work as a defense action for an eviction. So landlord's non-compliance as a defense to action for eviction. If the eviction is based on non-payment, the tenant may use a landlord's non-compliance as a defense or counterclaim in that eviction proceeding. Again, a tenant must give written notice to the landlord to avail themselves of any of these remedies. It's very important. A tenant is not allowed to bring this defense in eviction proceedings if they have not given that notice to the landlord. If no notice has been given, then the tenant is considered to have waived the violation entirely. So what happens when there's fire or any other kind of casualty damage to a property? Well, if the dwelling unit is damaged or destroyed by fire or casualty to the extent that normal use and occupancy is substantially impaired, the tenant may immediately vacate the premises and notify the landlord in writing within 7 days of their intent to terminate the rental agreement. So tenant has a week to put in writing that they intend to cancel the lease. If that's the case, the landlord must return the security deposit and any prepaid rent unless the fire or casualty was caused by the tenant's negligence or otherwise. Another option available to the tenant is that they can vacate any part of the property that has been rendered unusable by the fire. So if there isn't a total loss at the property, they can vacate from the damaged area and they can stay in the undamaged area, but the rent is reduced at that point in proportion to the diminution of the fair market value of the unit. So there are remedies for the tenant when they are unlawfully ousted or excluded from the property. This can be done through the landlord failing to provide these essential services, or for any other reason that the tenant is just being deprived of their access to the property. If that's the case, the tenant may recover possession of the property through an action in Magistrates Court, or they can terminate the agreement. And they may also recover 3 months' rent or 2 times actual damages, whichever is greater, as well as attorney's fees if they so choose to go that route. So the landlord also has remedies for tenant behavior. So if the tenant's breach is due to something other than non-payment of rent, the landlord must give written notice of the breach and state the lease agreement may terminate within 14 days, or in 14 days rather. This doesn't apply to failing to pay rent. As I say, it applies to things such as failure to maintain the premises, or due to things that affect health and safety, or the tenant's use and occupancy of the property. So the process is similar to what is required under tenant remedies. So the tenant, once they get the written notice from the landlord, they have the 14 days to remedy the breach in that time period, or if they cannot remedy the breach within that time period, but do what they can to get that process of repairs started, the lease agreement continues. If the tenant's non-compliance affects health and safety and requires repair, the landlord does have the option to enter the premises and start repairs and be reimbursed by the tenant rather than terminate the lease. They still need to wait for that 14-day period, however. So if the landlord is in a situation where the tenant has not paid rent, so the tenant gets 5 days after the due date to make their rent payment. But once that 5th day has passed, the landlord may terminate the lease agreement by giving written notice to the tenant. This written notice is only required once per lease period, and it can be included in the lease agreement. So the landlord does not have to wait for the non-payment of rent to occur. It is a notice that can be added to the lease at the outset of the landlord-tenant relationship in the lease agreement. So incorporating this written notice in the rental agreement also applies to any month-to-month tenancy after the agreement has expired. So typically, but not always, when a lease expires, the landlord-tenant relationship changes from a leased period of time to typically a month-to-month situation in which the lease can be either renewed or terminated at the end of a 30-day period. But this non-payment of rent notice would also apply after the lease has expired. So I gave the suggested language for the notice that the statute provides. It's pretty much just a form disclosure that landlords can use. I don't know if I have any landlords in the audience, but if I do, you can find what you have to put in your notice under the statute. If the tenant's non-payment is willful and is not in good faith, then the landlord is entitled to attorney's fees if they're represented by an attorney in Magistrates Court. So what's to be done regarding a tenant's property once they've left the premises? So after an eviction, landlord can remove a tenant's personal property from the premises. They must first give written notice to the tenant of their intent to do so. If the premises is abandoned or rental period is over and the tenant has removed a substantial portion of their property, or if the utilities have been voluntarily terminated by the tenant and the personal property remains, if the fair market value of the remaining property is under $500, the landlord may enter immediately and remove that property. If it's worth more than $500, then the landlord can still remove the property, but they're not liable for any damage to that property unless they've been grossly negligent in their activity. If needed, a landlord may use force to enter the unit. So if the locks have been changed, they can break those locks to enter the unit. So in situations where there is a standing lease that is in effect, but there's otherwise some sort of absence on the tenant's part or non-use or abandonment, then after 15 days from the first default of payment, if the tenant voluntarily terminates the utilities and there is an unexplained absence after this default of payment, then the landlord does not need to wait 15 days to enter the premises. So as I was saying, the landlord, if they suspect that the tenant has abandoned the property, they must wait 15 days after the default of payment before they can enter the premises. The exception to that being if the utilities have been terminated. Then the landlord does not need to wait 15 days after default. But when that happens, it is the landlord's responsibility to make reasonable efforts to rent the property at a fair market value so that they are generating their income again and not holding the tenant responsible for any overages in payment. So if the landlord does end up renting the unit at fair market value before the expiration of the rental agreement terminates, then the lease ends as of the date of the new tenancy. That's when the tenant who abandoned the property would no longer have liability. It would be at the start of the new tenant moving in. If the landlord fails to use reasonable efforts to rent the unit, such as they just let it sit there and let the lease tick off, then the lease agreement is terminated at the point that the landlord had notice of the abandonment of the property. So it's really in the landlord's best interest to get that unit refilled with another tenant when the situation happens. So let's talk a little bit about security deposits. So as I'm sure everyone here knows, security deposits are given at the start of a lease agreement to cover any kind of damage to the property or cleaning charges, things of that nature that might come up at the end of the lease. So when that happens and the lease is over, the tenant needs to give the landlord written request asking for the return of the security deposit. So the tenant must also provide the landlord a forwarding address so that the landlord can get the security deposit to them. But once this written notice is given, the landlord has 30 days to respond to it. And they can respond to it in in one of two ways, either by refunding the entire amount or refunding a partial amount and providing an explanation of any money that has been withheld, for example, for accrued rent or damage to the premises. It's very important that the landlord answers these requests for security deposits, because if they fail to respond, a tenant can bring an action in Magistrates Court for 3 times the amount of the wrongfully withheld security deposit, as well as any attorney fees that the tenant might accrue. So one of the things that I hear when I'm speaking to tenants when they have a situation, they are worried that if they, for instance, file a complaint with my department, that they may get retaliated upon somehow by their landlord. Well, the Residential Landlord Tenant Act kind of provides a little bit of protection for this, in that a landlord shall not raise rent above fair market value or decrease any essential services or bring any kind of action for possession if a tenant complains to a government agency about housing code violations. So a landlord who rents more than 4 adjoining units on a property can increase rent without there being a presumption of retaliation, so long as the increase applies uniformly to all tenants or the rent does not exceed the fair market value of the property. If the landlord does act in violation of this and they are determined to be retaliating, a tenant can bring an action for possession in Magistrates Court, and any landlord who acts in retaliation is liable for damages up to 3 months' rent or 3 times the tenant's actual damages, whichever is greater. So tenants have rights on a property that has been foreclosed upon. So in this situation, written leases survive foreclosure with an exception. If the new buyer of the property intends to live in the home as a primary residence, then the tenant has to move, but they get 90 days. They get 90 days to move out. If this tenancy is a month-to-month situation, then it's the same. The tenant gets 90 days to move rather than 30 days. So I've brought up Magistrates Court a couple of times. That is the court that has jurisdiction largely over landlord-tenant matters. It's where you will have your eviction actions. It's important to note that Magistrates Court tends to be a little bit more informal than what you would typically expect in court proceedings, and likewise have shorter notice periods. For instance, a tenant has 10 days to contest an order of eviction and request a hearing before a magistrate. If there is an order of eviction and the tenant requests a hearing, they must show up for the hearing, obviously, or they risk getting a default judgment against them. So yeah, if you're going to request a hearing, you have to show up. You can also request a trial by jury if that's what you want. And after the hearing, if the magistrate rules in favor of the landlord, they will issue what is known as a writ of ejection within 5 days. So it's a very fast process once an eviction action has started. Any appeal for landlord-tenant situations appeal to the circuit court. So that's pretty much it for my presentation. I have here on the slide some resources that might be helpful to you. Got the number here for South Carolina Legal Services. They may be able to assist in any kind of landlord-tenant issues if you meet certain income requirements that they have. You can look at lawhelp.org for more information on the Landlord Tenant Act. I give out the next number pretty often to people, not just for landlord tenant actions, but you can always call the South Carolina Bar Association Lawyer Referral Service to find information on an attorney that you may be able to consult with for a reduced rate. And then we have some other resources here for things that might explain the eviction process. For instance, we've got the Magistrates Court eviction summary here. Of course, you've always got my department. South Carolina Department of Consumer Affairs. Here's our phone number and website. We're happy to help provide advice when we can, so long as it's not legal advice. Not allowed to give you legal advice, obviously, but we can certainly let you know about the Landlord Tenant Act. We can certainly take a complaint against a landlord if the landlord is a business, such as a property management company, things of that nature. So we're here to help if we can. That's pretty much it for my presentation. If there are any questions, I'd be happy to try and answer them.
Yes, let me go ahead. I'll give a couple minutes in case there are any questions from the chat. But I did have a question. A few times you mentioned a quote unquote reasonable time frame for various issues. Has there been a precedent set for what that reasonable time frame can be?
Not yet, unfortunately. Reasonable time is something that comes up often in statutes. It has been defined in certain situations, but not all situations. I am not aware that it has been decided in landlord-tenant situations. It tends to be, from what I've seen in other types of issues, around 10 days. So that may or may not be binding for a landlord-tenant situation, but that's kind of a guideline that you may be able to use as far as what courts typically think a reasonable time is.
Okay. And another question that I had was, you mentioned written notice and how to get proof of written notice. Would an email with a read receipt or submitting a work order via a company website, would that qualify as written notice, or would it need to be something like certified mail?
It probably would satisfy the written notice requirement. I like to operate in an abundance of caution, and I recommend that people file or send their written notices certified, just so you've got that evidence. Of course, you could present an email read receipt or something of that nature to a magistrate, but I think that a certified receipt probably carries a lot of weight in magistrates' minds.
Okay. The other question that I saw coming up in the chat was asking if this will be available for reviewing at a later time. And because of some technical difficulties that we have recorded this session to be posted later. I will put out some information about that once I figure that out exactly. But unless there's anything else, thank you so much, Zach, for coming and sharing that information with us. I'm
Certainly. You're very welcome. Not a problem at all. If you'd like this PowerPoint, I can certainly send it to you so that you could distribute it if you need to.
Yes, that would be very helpful, actually.
Yeah, I can do that. I don't think any of our public information people are here today, but I know that our director would get pretty angry with me if I didn't mention these couple slides here. So we do provide publications upon request that can be sent to you free of charge. Some of our publications include this list here: Ditch the Pitch, ID Theft Prevention Guide, and our Credit Reports Guide. We have so many useful publications. You can request them on our website. I think you can actually find the PDFs on our website too. So just want to get that out there. And of course, you are always free to connect with us on social media: Facebook, Twitter, YouTube. We've got active accounts there, and they get updated pretty regularly. A lot of information on those.
Perfect. That sounds great. Yeah, and the other thing that I did want to mention, we do have some resources at the library. We have, if you are reviewing this and you need some help with some of the legal terms, we have legal dictionaries available here. And then call numbers 346.0434 do have some legal information there regarding Landlord Tenant Act. But again, thank you. And I don't think there are any questions coming up. So I appreciate you for joining us, our one attendee for the day. And
I hope it was useful information for you.
Definitely was.
All right then.
All right. Thank you so much.
Oh, you're very welcome.
Bye.
Bye.